I'll be on top again. I'm not gonna let you take me down. It's gonna be the whole nine yards or nothing.
Welcome to Legal Straight Talk. I'm Brett Harrison, and today we have a special guest, a labor law attorney, one of the areas he does.
Yes.
We're pleased to have Mike Cassel. He's an attorney here in Jericho. Thanks for joining our show today.
Yes, hi, good to see you.
Okay, Mike, just let me give you some of the ground rules. We try to take the legalese out of the legal world for people to understand.
I think I can do
So,
that.
okay, loosen the tie, and let's get ready to roll.
Okay.
So today we're talking about labor law. Now, most people say, well, what is labor law? And when people say that to you, one of the first things they come in and they say to me, to you, to anybody else is, well, I know I can't sue my employer. My employer was at fault, and they're going to get away with it because they're a big company, and I can't go against the big company because I'm a David versus Goliath. And I don't want to lose my job, but I got a family to support. I mean, you've heard the whole gamut.
Right.
So why don't you take me to first, when you say labor law and suing your employer, is that true that you cannot, or that's not necessarily the case?
Well, the aspect of labor law that I was going to talk about today is not suing the employer. I mean, there's many aspects of the labor law. There's parts of labor law that deal with people who aren't paid, their funds that they're owed, which of course are cases against the employer. But what I was going to focus on today was the aspect of the labor law for really construction-related accidents, which really apply to suits against either the owner of the site or the general contractor. Does not apply to lawsuits against the employer. That would be covered under workers' compensation if you're injured at a work site.
Okay, so just so we differentiate for everyone, we're not talking about wage aspect of labor law. We're talking about construction site injuries.
Correct. The
Okay.
labor law covers many things, including wage aspects.
But in this case, we only have a short amount of time.
Of course.
So we're going to focus on construction site. Why? Because people are always interested in that. Let's start with the basic. I know this sounds like a basic question and a silly question, but it's not. What is deemed a construction site?
Sure. Basically, a construction site would be a site that could really run the gamut anywhere from doing a total demolition, a rebuilding of a property, a tearing down of a building, to a reconstructing a building. But the labor law also applies to such things as painting. We've had cases where people are painting a classroom. It could apply to some types of even cleaning. So it really depends on the exact nature of the type of activity the employee is involved in. But typically they apply to construction type accidents.
Now, with construction type accidents, for the most part, are we dealing with certain types of hazards that makes it fall into what is considered construction law or labor law?
Sure. The main thing we deal with, the main aspect of the labor law that we deal with is a section called 240 subsection 1, and that deals with employees who are injured for what's called elevation-related hazards, which is a typical employee working on a scaffold or a ladder, and the ladder or scaffold moves, and the employee falls and gets injured. So usually you're talking height-related accidents.
So you're calling it elevation because they're suspended, whether it be by scaffold, ladder, or some other type of contraption that puts them up, whether they be doing window cleaning, perhaps, or painting, or something that involves anything elevated.
Of course, if an employee, for example, is outside of a building on one of those movable scaffolds that go up and down for window cleaning, and that scaffold breaks and the employee falls, that's clearly a 240 case. But what's interesting about the 240 is that not only does it apply to falling employees, but it also applies if the employee doesn't fall. So we've had a case.
What does that mean?
Well, we have a case right now.
I mean, you're not saying if he could have fell, but he didn't fall and he didn't get hurt. You're saying he actually what?
He actually, him or her, the
Right.
employee, for example, we have a case now where the ladder slipped, and to prevent the employee from falling, he grabbed the ladder as hard as he could with his right arm and tore his bicep.
So there was an injury as a result.
There was an injury to prevent the fall.
Okay, now that's one type of if the scaffold. What about falling objects on a construction site?
Yeah, correct. We also, the 240, section 240 of the labor law applies to falling workers, but also falling objects. So for example, there's cases out there where if a crane is lifting up some pipes and the pipes break free and fall onto an employee, that would be covered under the labor law. Also, for example, if the object that falls is an object that's supposed to be secured. So for example, if a piece of scaffolding falls on an employee. We have a case now where there was a temporary scaffold built in the structure, and a piece of the temporary scaffold fell, hit the employee in the back, upper back. That's covered under the labor law. So it covers a varied amount of different types of injuries, but the general type that we use, the language, is an elevation-related type injury.
Okay. Elevation meaning whether an object falls on you or you fall from a ladder or something.
Correct, but
to that.
an interesting aspect of it is the elevation differential could be what we use, and I know we're trying to speak the layman's terms.
What does that mean?
Well, it could be de minimis, meaning minimal. In other words,
Less than 10 feet?
it could be a situation where an object falls 3 inches. For example, there's a case where these employees are holding a huge hundreds of pounds cable wire that's in spools, and their job is to basically move these cable wires, and an employee's holding onto it. The cable wire, the big spool, falls down 3 or 4 inches, but because it weighs hundreds and hundreds of pounds, the effect of the spool moving causes the employee to get injured. That is covered under the labor law. So it's not always the distance, sometimes it's the effect and the weight of the object that falls.
So when you get it, when somebody comes to your office and asks you to evaluate a case, it's really a case by case. You can't say, well, it only fell 1 foot, 2 feet, 10 feet. It really is going to depend on the situation at the construction site.
Correct, because it may be a situation where either the employee falls, the employee gets injured preventing him or herself from falling, an object falls, or the employee is injured because an object that's extremely heavy may only fall down a few inches.
But now this is interesting to me. Now I'm thinking about the concept of construction site. Let's say there's ice at the construction site, okay, and let's say it's more than 24 hours, 48 hours, whatever it may be. Obviously, when you have construction workers and dealing with heavy objects, falling objects, ladders, and so forth, a little bit of ice could really be a hazard. Would that actually make it as a claim for labor under Labor Law 240?
It could. It could also under other aspects of the labor law, such as, there's a section 200, which basically applies to a general duty of an owner to keep the site safe for employees. And it may also apply to another section, which is section 241 of the labor law. But generally speaking, 240, there are certainly cases out there where an employee sets up a ladder, and the only place the employee can set up a ladder is on a ground that maybe isn't, the concrete maybe shifts or moves, or it's not a good ground, and that would be a 240 violation. Just keep in mind, under 240, there's no offset for employees' own negligence. So it's a very powerful
Well, when you say
statute.
there's no offset, let's take that down to plain English. So yours is, well, all right, you define that.
Sure. In layman's terms, if the employee does something dumb, such as setting up a ladder maybe on ground that isn't 100% stable, or for example, there's cases out there where the general idea is an employee is told to make sure before you use that ladder that another employee holds a ladder. And the employee says, you know what, I'm busy, I'm going to use the ladder anyway, goes up on the ladder, and the ladder slips and the employee falls. Generally speaking, the argument that the employee did something wrong, was dumb, so to speak, is not a defense. The employee is still entitled to succeed.
So let me ask you a question then, because this kind of is an interesting one for me. Let's say on your same scenario, the employee, he sets up the ladder. On the same scenario, he puts it on gravel, uneven, something that's not too smart to do. But this time, let's add another element to it. The person was drunk. The employee was drunk. Are you telling me now, even though he's drunk, the employee, so obviously the concept of being drunk is it impairs your ability to think clearly, or maybe even to step properly, or even set it up properly. You're saying that it wouldn't make a difference if he's drunk, he or she.
The cases run the gamut, but generally speaking, no. The general rule in New York is that if any part of the reason why the ladder in the situation, the ladder slips and falls, or the employee falls, is because him or her is given a ladder that doesn't properly protect them from falling, then the employee is entitled to succeed. So a defense such as the employee, shouldn't have been using the ladder in a certain manner, or shouldn't have put it on gravel, is no defense at all.
But what about the concept now that the person's drunk? Obviously, the whole concept is an impairment of judgment. So that is not a defense. And when we say defense, we're talking about does the whoever they're suing, the owner of the site or what have you, have a defense against a labor law violation?
Merely showing that the employee was drunk would not be a defense to a labor law claim as long as the employee could show that there was a violation of the statute. Let me give you an example. Generally speaking, when an employee goes up on a scaffold, the employee should be provided with guardrails around the scaffold. We deal a lot of cases with mobile scaffolds. They're called Baker scaffolds, and maybe 4 or 5 feet high. So there are cases where the employee is given a scaffold
Right.
with no guardrails, and the employee is working up on the scaffold. The scaffold shifts or moves for some reason. Something maybe bangs into it, and the employee falls. The mere fact in that situation the employee might have been drunk, under the weather, sick, is not a defense because the accident was caused, at least in part, by the failure
Right.
of the owner to provide the employee with a safe device. That's the key. Was the device safe? Was the ladder?
Well, that I
itself-
understand.
Right.
Okay, now let's take it a step further, because I'm still bothered by this concept a little bit of that the employee's possible negligence we use as the proximate cause or was the real cause of the accident. Let's say you have a ladder, and the employee could have taken the ladder to go down 1 flight, 2 flights. Instead, the employee says, you know what, I'm just going to jump down, and I'm not going to use the ladder.
Correct. It is a defense to the
That would
labor
be a
law.
defense then?
That is defense. I mean, there's generally 2 defenses that are raised, and just to take a step back, generally speaking, the labor law would apply to claims against the owner of the site or the general contractor.
Can you differentiate the two of when each would possibly be, give a couple of easy scenarios or typical scenarios that you see when it's generally the owner of the site or the general contractor and or both?
Yeah, usually it's both. The key is most of the cases that we deal with, if it's a straightforward construction case, in other words, a case, for example, where we have a case where they're working on the building of the World Trade Center. So there's an entity that owns the World Trade Center. That entity is responsible under the labor law even if they have no connection whatsoever with the construction. The mere ownership of that site makes them responsible under the labor law. The general contractor is typically the entity that's on the site that's hired by the owner to usually oversee the construction project. And they usually have someone on the site that's working. That entity is also separately liable under the labor law. So usually what the employee does, an employee is injured, they'll sue the owner, and they'll sue the general contractor, and they'll also sue any contractors that are in the chain between their employer, because they can't sue their employer, and the general contractor.
Now, how long under the labor law do they have to sue?
Well, usually if it's a negligence type claim, in New York, it'll be 3 years in which to sue. So it's usually 3 years in which to sue.
What about under a labor law violation?
It's usually 3 years. I mean, the case is brought within 3 years.
Are there any exceptions to that, where it could be longer?
Not usually for a negligence type case. I mean, it's 3 year statute of limitations. But just to if I go back to that question before,
Okay.
there's usually 2 defenses that the defendants raise on labor laws, which is either a proximate cause defense or recalcitrant worker.
Can you explain what?
Sure.
Start slow with proximate cause.
Sure.
That's again a legal term.
Proximate cause means that the sole cause of the accident was the employee's own misdoing, so to speak. So the example that you gave where the employee, instead of using a ladder, decides to simply jump down and injures himself because he decides to jump down 4 feet off, say for example, off this desk, which would be, and jumping down, that would not be a labor law violation because the injury was not caused by an improper ladder or a scaffold or other type of elevation device. The other defense that defendants often use is called the recalcitrant worker defense, which means basically the worker ignored a specific instruction. So for example, if the worker is told, if you go up on that scaffold, you better make sure that you're tied in place. Sometimes the workers are provided with a safety harness. If the employee is specifically instructed to use a safety harness
And they
if-
disregard it.
Correct. That could be a defense also. So those are the two main defenses.
Huh, that's interesting. Now, let's say they just use bad judgment. Let's say they try to lift a big beam themselves. Okay, and that's, based on the length, not one person could possibly do it. Or it's really heavy. And as they try to lift it, it falls on them. And that wouldn't that fall under? I just don't see, they've taken not direction to do it, but they just take it upon themselves.
Well, lifting a beam or an object, and then if it falls on the employee, would not be a 240 violation because the object itself is supposed to be held by the employee. So that's not a violation. However, if the employee is up on a ladder and the employee, let's say, is cutting down pipes in the ceiling as part of demolition,
Granted.
and the pipe falls and hits the ladder, even if the employee is, I hate to use this word, but want to make it layman's terms, is dumb by putting, say, the ladder right below where the pipe will fall.
Sounds like a Three Stooges thing.
Right.
The pipe falls on him, the scaffold breaks, he then falls down the ladder, and it's almost like it's basically a Three Stooges.
That's correct. You have in that situation, you have a falling object and you have a falling employee. But that would be almost certainly a 240 violation.
But that's height related.
Correct.
I'm talking about if you're actually standing on the ground and you see a big beam, for example, and you say, you know what, I'm just going to lift it. I got to get it away from me.
That's not a 240 violation.
And then let's say, because it's so heavy, the person gets it up, and then it falls and let's say they rip out their arm, they hit their foot, and obviously with the weight of something like that could
Correct.
impair them. That would not.
Correct, that would not, because it's not an employee falling, there's no elevation-related difference, and the object that fell was something the employee, him or herself, was
So that would be a defense then.
That would be a defense, that type of case. Correct.
Okay, that's what. Now, let's talk about, so people understand the difference between a 240 case, which let us call that could be absolute liability, versus negligence. And these are two different terms that are thrown around with attorneys, defense attorneys, judges, and I really don't think people understand that you could have a cause of action when you're suing as a plaintiff for the one that's injured, the employee that's injured. You could have a negligence claim and also an absolute liability claim. Can you explain the difference? So in layman's terms, so people don't understand what the heck we're talking about when we use those terms.
Sure. Well, there's many different statutes of the labor law, but the one statute that we're talking about, which is labor law.
Well, I'm talking
Section
about
240.
in this case 240.
Correct. The beauty of that statute is, generally speaking, like for example, let's take a step back. There's a car accident. I could be injured in a car accident. Under the law, if I'm 30% responsible for the car accident and I collect $100,000, that'll be reduced down to $70,000 because they'll offset my $30,000 responsibility, 30%. Under the labor law 240, even if the employee is partially responsible, for example, there's cases where an employee is told they're doing work on a roof and there's open skylights on the roof. The employee is told, you know what, don't go in that area. The employee, because of his or her work, winds up going in the area, falls through the skylight, which in layman's terms is probably not the smartest thing to do. There's no offset. Since it's a violation, it's an elevation-related hazard, the employee fell, the employee wasn't properly protected, the employee will collect 100% of the damages from either the owner or general contractor.
Despite the fact that they were, their own actions were arguably part cause of this.
Correct.
That's why it's called absolute liability. We don't care.
Correct. There's a case where an employee is tasked with building his own scaffold, and he puts on the wrong wood on the top of the scaffold. He puts on wood that isn't properly protected, uses the scaffold breaks. The employee moves for labor law for summary judgment under 240, and also, if we have time, we'll discuss 241. The court holds that under the labor law 240, even though the employee made a mistake in using the wrong wood.
Bad judgment. So bad judgment is not a bar when you deal with absolute. Matter of fact, it
not a
doesn't
bar.
even affect the absolute liability.
Correct. It's 100%. The
So-
plaintiff can recover 100% in that
So
situation.
that's why when an attorney is evaluating a case, if they see that there's a labor law violation or a potential labor law violation, they generally say, okay, now we possibly have something here despite the potential actions or negligence.
The other beauty, exactly, and the other beauty of the labor law is it's one of the few areas that we deal with that is very plaintiffs-oriented and liberal. In fact, the cases will say that the labor law is put in place to protect employees. The reason why it's written is to protect employees. So to a certain extent, the benefit of the doubt will go to the employee who's injured. I had a case recently that went up on appeal
Right.
in New York, and the plaintiff had fallen off of a mobile scaffold because a guardrail wasn't in place. And I was doing an oral argument before the appellate court. It lasted all of 8 seconds. The appellate court asked me, is it true, counsel, that guardrails were not in place on the scaffold? I said, yes. They said, thank you. That
Please
was
take
it.
a seat.
Please take a seat.
And when a judge tells you, especially an appellate judge, okay, and asks you the question and they get the answer, it's one of those things when you just shut up.
That's
Do
right.
not say more.
I tell my wife, if you ever go to an oral argument, look to see who's speaking less, because that is a side that is probably going to win. So the court...
Unless it involves a marital dispute between husband and wife. That talking less does not mean you're winning.
That's true. That's true.
But that's another show.
That is. But the court, the first department in that situation, affirmed we won. In other words, the employee set forth a claim of a 240 violation.
Right.
But guardrails weren't in place on the scaffold. That is sufficient on that
Ball
case.
game's over.
Ball game's over for the owner of the site. That's it. If you don't provide the employee with a proper device, that's pretty much it.
Now, just so people understand, once you establish the liability, the next phase, or to somebody that's on the other side, to the defendant's attorney, they then say, well, when they evaluate a case, they say, well, is there liability? If it's absolute liability, then the next question is, how much is the case worth?
Correct.
And then you go into other factors, was it pre-existing, but that's a different aspect. And then permanency, and there's a whole bunch of stuff that goes into damages, but that's not what this show is about. But just so people understand, once you have the liability, the first part, before you get to the how much in a case, how much is my case worth, we got to say, hold on, can we establish liability?
Correct.
And when you say we've established absolute liability, now the next phase is actually, okay, now let's get into a discussion on how much is my case worth. Now let's go back to negligence. Now, the difference of negligence has a whole bunch of different defenses.
Right. Well, negligence does apply, as generally speaking, to the other aspect of labor law, which we deal with, which is a 241 subsection 6, which is basically a construction-type accident where there's a violation of what's called the industrial code. For example, there's an industrial code provision that says, generally speaking, that a work site should be free of debris. So generally speaking, if an employee was to be injured because the employee falls and slips on debris,
Right.
that would be, generally speaking, a labor law 241 violation. However, the owner could argue and would get an offset if the owner was to demonstrate that the employee was negligent. The employee should have seen the debris on the floor, should have avoided that debris.
When you say an offset, you're saying now the jury or can award and say, well, they should have seen it, they were at least 50% liable. That would be an offset to whatever. If they got, theoretically, $500,000, an offset of 50%, they would be awarded $250,000.
Correct, and that's the way it works.
Or theoretically, they could be found, even though they were in violation of an industrial code, it was so egregious and in front of them, they could actually be deemed almost 100% liable.
They could be. Let me go back to the example where the employee built the improper scaffold. In that situation, when the employee used the wrong wood, the court found the employee was entitled to succeed on the 240 claim because the scaffold was an improper scaffold,
Right.
but held that there was a question of fact as to the amount of the offset, if any, on the 241-6 claim. 241, there was an industrial code regulation that applied to the materials and scaffolds in general. There's a lot of different provisions, but the owner of the site argued, well, the employee knew and used the wrong wood. That is an issue that the jury would decide.
So just so the audience understands, a lot of times, an attorney, when they do a summons and complaint, will do more than one cause of action. In other words, it could have the 240 action, a 241, a negligence. It could have a myriad of claims.
Correct. And negligence, generally speaking, there's a labor law statute 200, which applies to general negligence. So almost always we'll assert a claim for 240, 241, and 200. Those 3 labor law statutes are what I deal with mostly, and keep our fingers crossed that we succeed on 240. Why is that? Because that's the one statute that doesn't have any offset for the employee's negligence. And we also many times move what's called summary judgment, which is, though as you noted, there's 2 aspects to a case, liability and damages. We'll ask the court as soon as possible after, when we're allowed to ask the court to find as a matter of law that we've set it for the 240 claim. And the reason why we do that is because interest starts to run from the date of that determination, even if the damages are decided months or years later.
Huh.
You get pre-interest.
Mike, the half an hour went very quickly, as you say. I want to thank Mike Cassel for coming in today. He's an attorney from Jericho. Once again, it's Brett Harrison for Legal Straight Talk. You can watch us on our internet at hlgny.com. Thank you once again.
Give my regards to Broadway. Remember me to Herald Square.
Hi, I'm Jerry Parisi. Join Tom Mealy and Tommy Marr right here on Cablevision Channel 20 each week for an interesting episode of The Long Island View.